very much. This is great. I'm very happy to be here. I'm also still just admitting people. We've got quite a few people here today. We're up to 56, and
I'll take care of that. Don't you worry.
over to you. Okay. You get so used to multitasking.
I know. I got
world, right? Like I can't see admit without hitting the button, right? It's just,
I know.
Just
You
like
relax.
Impulse.
I'm your helper today.
Anyway, thanks. This is great. I'm really actually pleased to see how many of you are out here today to have this conversation, because this whole field, this whole subject of confidentiality in family mediation, as well as the application of these concepts to family arbitration and parenting coordination, to the extent that any of you are doing that work, is very important. And it's probably become more important. Well, it has become more important since the Supreme Court of Canada took it on last year. And so I'm going to be talking about that case, as well as some others that will hopefully be helpful to you. This is a version of a presentation that I did at the Ontario Bar Association in October of this year. I've changed it up a little bit, but it's fundamentally the same material. And as Marianne said, it's based on a paper that I wrote for that event. So let me share my screen with all of you now, and hopefully you can all see this. And I will now start. There we go. Okay. So, and I'm gonna just let my little doggy out. All right, law of confidentiality in family mediation. So I've tried to make it a little bit light today, because this is otherwise a bit of an intense and heavy topic. This is really important. Clients come to us for many reasons, but one of the most significant reasons that people will choose you as a family mediator is their desire for confidentiality. People want a process that's private and confidential for many reasons. And so most of us, unless you're doing open mediation, which we're going to be talking about a little bit later, most of you are promising confidentiality as one of the things that you're selling. We usually include confidentiality provisions in our contracts, and therefore you do not want to be in breach of your agreement to mediate. So that's reason number one why this is important, is to be certain that you understand what your agreement says, what it actually means, and that you can comply with what it says. This carries over into your work, as I said, as a parenting coordinator or a mediator arbitrator. That's if you're providing closed services. And some people provide open parenting coordination, some people provide open mediation, and those aren't confidential processes. So we'll differentiate those as we go along. You don't want to be that mediator in that reported decision. That's the other main reason why we take this stuff seriously. So I've structured this in 5 parts, and here are the 5 parts. And I've tried to be a little bit lighthearted about it. Number one, what is Wigmore? If you don't know what Wigmore is, you will learn about Wigmore today. Number 2, why did the Supreme Court do that? Number 3, my head hurts. Confidentiality, exceptions, open and close without prejudice. Number 4, some more cases. And then number 5, the best part, which is best practices and hopefully useful templates. Okay, let's start with what is Wigmore. Wigmore is a rule of the common law. So you will not find Wigmore in any statute or any regulation or any rule of practice. Wigmore is common law, and it is the rule used by the courts to establish the circumstances in which confidentiality should prevail. So it's the rule that the courts apply when, for example, the mediator, God forbid, forgets to sign an agreement to mediate, or where there is no agreement to mediate applicable in the normal course, but something important is at stake, and you need a test to determine whether this is that kind of situation that should be treated as confidential. The 2006 Rudd and Trossachs case, and by the way, in the paper, which is on our website, and I will be sharing it with you at the end, but you can find it on the website. Oh, and I'm just going to mute everybody. Sorry, bear with me. I'm just going to mute everybody here. All right. So okay. Rudd and Trossachs. Rudd and Trossachs was a 2006 decision of the Ontario Superior Court of Justice that, in a very helpful way, looked at this concept of confidentiality and common law confidentiality. It was a case dealing with a mandatory mediation, which is in civil matters in Ontario. And the court in that case was asked to compel the mediator to testify about who was and who was not a party to a settlement that purportedly took place during the mediation. There was a signed agreement to mediate in that case that did provide for confidentiality, but notwithstanding that, the court also looked at whether that contract should be upheld by applying the Wigmore criteria. And this was the principle around confidentiality that comes out of the Rudd and Trossachs case. Really important, right? The ability of the parties to engage in full and frank disclosure is fundamental to the mediation process and to the likelihood that it will lead to a resolution of the dispute. There's a danger that parties will be less candid if they are not assured that their discussions will remain confidential. So absent overarching considerations, such, for example, as criminal considerations, and we'll talk about other exceptions in a moment, there is the starting point expectation that mediation should be confidential. The court did conduct a Wigmore analysis. So Wigmore is the analysis that sets out these 4 steps. Number 1, the communications must originate in confidence. So there must be an exception, an expectation in the relationship in which these communications took place, that they were taking place in confidence. That's number 1. Number 2, confidentiality is essential to the maintenance of whatever that relationship is. So think therapist-client, for example. Okay. Number 3, the relationship is one that in the view of society is worthy of protection. And number 4, a disclosure of the information would do more harm than any benefit gained by the correct determination of the particular matter. In other words, the harm done to this relationship as a whole, or the harm done to others, if the precedent is set that confidentiality would be breached, that damage is greater, that harm is greater than whatever benefit might be derived by having that information as the decision maker in order to make the most correct decision you can. So that's Wigmore, 4 steps, really important steps. And you can see that the 4th condition is really the important one. It's the one that usually the courts are able to breeze over the first 3 fairly quickly. It's the 4th step that courts dwell on, and they really take their time to make sure that they have balanced correctly, right? There's a public interest, obviously, in having information disclosed, but there's also a public interest in maintaining the expectation of confidentiality in certain important societal relationships. So Rudd, in that case, the court protected the confidentiality of mediation. And in that case, and often, these cases are often distinguishable on their facts, but in that case, the court noted that there was other evidence available of who was party to this settlement and what those settlement terms were. So the court upheld the agreement to mediate, and confidentiality of the mediation process was upheld in Rudd. So important case to start with. So now let's move to number 2. Why did the Supreme Court do that? And of course, what we're talking about is why did the Supreme Court of Canada rule as it did in Association de Médiation Familiale de Québec versus Bouvier. This was a really important decision of the Supreme Court of Canada that came out in 2021, considering the concept of settlement privilege. And settlement privilege is a term that you'll want to become familiar with. It is the term that means without prejudice settlement conversation. So there is an expectation when parties in litigation or parties in mediation, parties between their lawyers are discussing settlement, that those conversations are privileged, right? And that privilege is important because it protects it allows parties to make offers to settle, for example, and not be prejudiced by doing so, except perhaps later in a cost sense, right? So settlement privilege is an important concept. And I just referenced the Union Carbide case, for those of you who are interested in reading up on further case law in this field, because Union Carbide was really the first important case dealing with settlement privilege in the mediation context. So the Supreme Court of Canada in Bouvier considered the exception to settlement privilege. In other words, when will a court override this expectation, not of confidentiality, right, which is what we were talking about in Rudd and Trossachs, but of settlement privilege, right? When will a court override that expectation that proposals and offers and so on are made without prejudice, or settlement privileged communications? And the exception to settlement privilege, therefore, is a rule that allows otherwise protected communications to be disclosed for very specific purpose, okay, in order to prove the existence or the terms of a settlement. Okay, so it actually is in a practice very similar to, or in effect, very similar to the principles set out in the Rudd case. And part of this you can see is helping all of us understand why this field has become so confusing, because even in court decisions, the terms confidentiality and settlement privilege or without prejudice have been used interchangeably. And one of the things that I'm hoping will come out of this presentation for you today is a differentiation between these principles of confidentiality and without prejudice or settlement privilege. So settlement privilege, right, and the exception to settlement privilege is the idea that in certain circumstances, the court should be able to override settlement privilege in order to assist a party to prove that a settlement was reached or to prove the terms of the settlement. So let's look at Bouvier. In Bouvier, this is a really fascinating case. The parties attended a free court-connected mediation in Quebec. So they have a similar program in Quebec to the one we have in Ontario. The parties signed an agreement to mediate. The agreement to mediate provided for confidentiality of that process. And so the parties participated in what they understood was a confidential, without prejudice negotiation process. Afterwards, the mediator drafted what they call a summary of mediated agreements. So that's very similar to our MSR we have here in Ontario, a mediation summary report, or MOU. And as here, it was not signed by the parties. So what happened after the mediation? The parties carried on as though they had an agreement. And this is a really important point. They completed several of the steps set out in their summary of mediated agreements, never signed a consent or minutes of settlement or separation agreement. But at some point, when one of the so-called settlement terms came up, one of the parties balked and said, no, I didn't agree to that. And took the position that because the summary of mediated agreements was not binding, just as similar to what we have here in Ontario, there was no settlement. And the other party therefore went to court, sought to enforce the settlement made at the mediation, and wanted the notes from the mediation and the summary of mediated outcomes to be produced in evidence to support their argument that a settlement was indeed reached at mediation. What the Supreme Court found that was because of the parties' subsequent conduct, there was clear evidence that they had reached an agreement at the mediation, and that subsequent conduct was sufficient to prove that there was a clear agreement reached at the mediation, a true agreement reflecting the terms recorded in the summary of mediated agreement. So because there was subsequent conduct supporting the argument that an agreement was reached at mediation, the Supreme Court allowed information from the mediation, which otherwise would have been settlement privilege, to be put into evidence. So the Supreme Court ruled that the exception to settlement privilege applied. And I want to point out the importance of the fact that this was done because there was post-settlement evidence outside of what happened in the mediation, outside of the summary of mediated agreements, independent evidence, steps taken by the parties that in itself was evidence of a settlement, that on that basis, the exception to settlement privilege applied, the summary of mediated agreements could be considered to prove the terms of the settlement that was evidenced by this post-mediation conduct. So that's an important point. And at the time when this decision came out, it made sense to me, right? That if you're going to have parties acting on things and behaving in ways and demonstrating them by their behavior that they reached an agreement, that's very different from the situation where parties go to a mediation, they, the mediator drafts up a mediation summary report, and then later, immediately afterwards, one of them changes their mind, right? They're very different circumstances, and I think it's important to bear that in mind. The other really important thing is the Supreme Court noted that the parties could have, in their agreement to mediate, opted out of this exception to settlement privilege, okay? And the other really interesting thing about this decision, if you care to read it, is the dissent is amazing. The 3 dissenting judges wrote, in my view, a very compelling dissent that is a testament to what we do as family mediators. So I recommend the dissent to you. Right, okay. So that's the Bouvier case, and that is settlement privilege and the circumstances in which settlement privilege can be overridden. Okay, we'll come back to that in a minute. Let's go through some other terms, because this is where my head hurts. Part 1, confidentiality. Confidentiality means that, what happens here stays here. Neither party nor the mediator will speak with anyone outside the process about what was said, what was written, what was done, what was proposed, what was shared, right? This is what makes mediation that safe place to have difficult conversations. And this is so important in family cases, as you will all know, because there are so many outside parties who want in, right? Or who the parties may want to bring in. And oftentimes parties in family mediation may seek to use outside parties to gain unfair advantages, right? They may want to bring teachers in, or neighbors in, or parents in, right? Or caregivers in, and talk to them about what's going on in the mediation to seek, to gain allies or to gain leverage. And that can make mediation very dangerous. So confidentiality is one of the tools available to mediators, right? To balance negotiation power. It limits the ability of a party to seek to improperly influence the process by manipulating information for unintended purposes. And that's a really nice way for you to explain to your clients what confidentiality is. It just means neither one of you can talk to people who aren't here about what's going on here, because that's going to make you feel very vulnerable, right? And I mean, one of the really interesting civil cases that demonstrates this is where the parties went to a mediation, and then one of them, after the mediation, took out an ad in the local community newspaper talking about what happened in the mediation, right? Well, that's a clear breach of confidentiality and a clear improper use of the process to gain leverage, right? So it's a good way of explaining it. And it's particularly important, as you all know, in our world of family mediation because of screening, right? Screening for power imbalances, infringement, partner violence, has to obviously be completely confidential in order for parties to be able to safely disclose this information to us. So it's completely confidential, subject to, of course, my head hurts part 2, exceptions to confidentiality. We all live with exceptions to confidentiality, and you want to get in the practice, if you're not already, of always explaining confidentiality and exceptions out of the 2 sides of your mouth, and don't talk about one without the other, because you don't want to mislead anybody into thinking that your mediation process is completely confidential. Parties aren't. This is a process of self-determination, of informed self-determination. You don't want anybody feeling tricked into thinking that you lured them into this confidential process, and then they told you something, and then you went, oh, sorry, I have to report that to the Children's Aid Society. Okay, that is not fair. That's not doing your job as a mediator. So make sure everybody knows from the outset that you are subject to standard exceptions, and practice saying these, right? Mediation is a confidential process. However, there are exceptions to confidentiality, and it's important that you understand those exceptions. The first one, if I get any information suggesting that a child is in need of protection, I have a duty to report that to a Children's Aid Society under the Child, Youth, and Family Services Act. Secondly, if I get any information that makes me concerned that you or any person is at risk of imminent or serious harm, I may have a duty to warn that person or to otherwise take steps to protect them. And thirdly, on very rare occasions, mediators are ordered by courts to breach confidentiality and give evidence about what happened in the mediation. And this typically happens in child protection cases or in cases where there are criminal charges laid. Do you have any questions? Okay, make sure you take the time to explain to your clients the exceptions and what they actually mean and how they might apply to them, and then give them a chance to think about it and say, yes, I understand. Okay, because no matter how well drafted your agreement to mediate is, you can't contract out of these. Okay, so that's important. My head hurts part 3. And this is where your head really starts to hurt in Ontario, is the difference between open and closed mediation. This is so confusing and it's so unfortunate. So let's start with the easy part of my head hurts part 3. Closed mediation is easy. It is closed. It's confidential, right? And it's without prejudice, full stop, subject to the exceptions, of course. And fun fact, in case you didn't know this, all court-connected family mediation in Ontario is closed, even if it's called open. Okay, so this is where your head starts to hurt. I'm not going to get into it other than to say, if you're doing court-connected mediation, you have to read very carefully the language of the agreements to mediate and see how they describe open and closed mediation. The only difference is in the amount of detail you're allowed to put in your mediation summary report. It is all closed and confidential, no matter whether it's called open or closed. So, and all on-site mediation, of course, is always closed. So be very thoughtful about that and read that carefully. The danger of open mediation in the court-connected context, even though it's still confidential, is that it's confusing to people because it's called open. And you may have people who don't understand that open means closed in the court-connected context. They may think that open means open, which is kind of understandable. So what's normal open? It's just not closed, okay? So open mediation is however it's defined in the agreement to mediate. And it means it's not confidential. It means that the mediator may, subject to what the agreement says, be called to testify. The mediator may be asked to give a report. The mediator's notes or mediation summary reports may be available to the court. So it has, if you're going to do open mediation, make sure your agreement to mediate very clearly and in great detail explains what exactly open mediation means in your agreement. So know these definitions, and again, be very familiar with them and able to explain them clearly to people. Okay, my head hurts part 4, without prejudice. So again, the terms get really head spinning, right? Because without prejudice is settlement privilege, right? It's the same thing. Without prejudice is this legal concept that parties can make proposals to settle their disputes without that prejudicing them legally if their proposal isn't accepted, right? Nobody wants to be able to make an offer, the other party rejects it, and then later it gets thrown in their face in litigation or prejudice them in some way. The whole point of without prejudice or settlement privilege is to encourage parties to go the extra mile and try and settle their case, knowing that if that offer isn't accepted, it can't later be held against them, or they can't, at the last minute, be prejudiced by what they offered. That's other than, the rules of the family law rules provision for cost consequences of offers to settle, which I'm not getting into. Okay, so again, without prejudice also creates that safe space for our clients to have difficult conversations, because it allows them to be those crazed, unreasonable, irrational, unhinged people that we sometimes see in mediation, and that's totally okay, right? So in a weird way, without prejudice and confidentiality actually allows us as mediators, these are gifts to us, because this is what allows us to truly be non-judging, right? Truly be curious and truly, say that's okay. You are allowed to be those ways in mediation, and I am not going to judge you for it. In fact, I welcome that. Okay, so that is the end of my head hurts. Let's now look at your agreement to mediate and some case law. And again, there are links to all of these cases in the paper, which I'll show you where to find it at the end. Okay. Your agreement to mediate is so important, and whatever you're using, unless you're doing court-connected mediation, in which case there's nothing you can do other than write the ministry and ask them if they'd consider changing their agreement to mediate. We are bound as court-connected service providers to use the agreements to mediate that we're given, which are, by the way, very good. In private practice, you want to really know your own agreement to mediate. You want to stay current with the case law. You want to change your agreement to mediate as needed. And we're going to talk next about some ways in which you may want to consider changing your agreement to mediate to respond to particularly the Bouvier decision. Just to give you some examples, Benson and Kitt, this is a case where the Riverdale mediate, so the agreement to mediate that I created was interpreted by Justice Monahan to mean exactly what it was tended to mean, thankfully. In that case, one of the parties became unhappy about what was going on in mediation and sought production of the file of the mediator, including screening notes and intake forms, right? Absolutely appalling. But nonetheless, they tried, and thankfully, Justice Monahan shut it down very quickly. So recognizing the importance of, in that case, Justice Monahan spoke about settlement privilege, right? So again, the decision, in my view, isn't quite perfect, because I would have preferred that Justice Monahan spoke about confidentiality rather than settlement privilege, because really production of the file, screening notes and intake forms, that's not a settlement privilege issue, that's a confidentiality issue. Never mind, the outcome at least was the right one. The next case, which is an important one in my view, is an unreported decision, Arbuckle and Arbuckle. And this involves this is just a really good example of what not to do. Justice Lemon ordered the production of the mediator's notes in this case. Why? Because there was no signed agreement to mediate. Okay, you do not want, obviously, to be in the situation where all of a sudden you realize that you forgot to get the agreement to mediate signed by everybody. So, and especially I'll say, since since Zoom, since everything started online, it's been quite challenging, right? I don't think any of you will find it surprising if I say it's been very challenging to administratively make sure you're doing everything right in this time, because everything's being signed in Counterpart, everything's being signed using signing technology or plugins. Everything takes twice as long administratively, and you want to make sure your file's well organized and that you triple check that your agreement to mediate has been signed by you, has been signed by both parties, and anybody else who needs to sign it. And that you have that copy available to you if you ever need it. In the Arbuckle case, Justice Lemon, even though there was no signed agreement, or because there was no signed agreement, Justice Lemon applied the Wigmore criteria, okay? And applying Wigmore, Justice Lemon found that the confidentiality was a reasonable expectation of this process, because there was evidence that the parties expected it to be confidential. They'd actually previously worked with another mediator, so they understood the mediation was confidential. However, Justice Lemon found that there's no contract preventing disclosure of the mediator's notes, and therefore the exception to settlement privilege prevailed because the question was whether there was or was not an agreement. Okay, so just a really good case for you to read. The next case that I just want to talk about is the Butler decision. This is a more recent decision involving a signed agreement to mediate, providing for closed confidential mediation. After a long day of mediation, the parties reached tentative agreements, or so it seemed, and the mediator dictated right there with everybody in the room a memorandum of understanding, setting out what the mediator understood to be the terms of the agreement. And among other things, the mediator said, if I've got any of this wrong, get back to me promptly. because I'm considering this to be a binding agreement. So a week later, the wife wrote the mediator and said, that's not correct. I didn't agree to everything that's in the mediation memorandum of understanding. The husband replied that he thought it was binding, and the mediator confirmed that he believed it was unambiguous. So the wife refused to comply with the terms of the agreement, and the husband brought a motion to compel the settlement. The husband wanted to rely on the memorandum of understanding and other information from the mediation to prove that there was an agreement. So Justice Andrea Himmel went through all the steps, including applying Bouvier. She looked at what happened in this case, and she concluded that this was an appropriate case to override settlement privilege. So even though the parties had this was confidential closed mediation without prejudice, all those clauses were there. She said that, you recall when we were looking at the Bouvier case, the Supreme Court of Canada specifically noted that the parties could have opted out of this exception to settlement privilege, but they didn't. So that's what Justice Himmel did. She said, I see that there is a agreement that provides for confidentiality. And this is a standard clause, by the way, that we all use. It may be worded differently, but we all pretty much, up until Bouvier, had the same language in our agreements that provided for closed, confidential, without prejudice mediation. But very few of us, if any, were adding that clause, contracting out of the exception to settlement privilege. So in this case, there was no contracting out of the exception to settlement privilege. So Justice Himmel found that because they didn't contract out of that exception in their agreement to mediate, they must have expected the exception to settlement privilege to be available. So she allowed it. And she said, in this case, I'm going to look at whatever evidence I'm being asked to look at coming out of the mediation in order to ascertain whether, what the existence and terms of a settlement. And she did that and found there was no settlement. Okay, so she overrode the settlement privilege or the without prejudice nature of the mediation, looked at the evidence before her and said, based on the evidence before me, I don't think these people reached an agreement at mediation, and therefore I'm not going to enforce the outcome as the husband's asking me to do. Okay, so really interesting case. And we can look at some of the details of these and say, how is this different from Bouvier and so on. At the end of the day, the message for all of us is we need to be very thoughtful about what we put in our agreements to mediate and make sure that they're doing what we're promising, that we're delivering on our promise to clients, and that we understand what the agreement says, what it doesn't say, and what it means. So let's talk then about some of the best practices coming out of all of this. Number one is clear, right? Draft your documents with care and consistency. We all have many things that we say or give to clients when we are selling our services. So we are we're salespeople and we are selling something. We want to make sure that we're being honest and accurate in our marketing. And we also want to make sure that all of our legal documents that we're having clients sign and everything that goes along with our process is consistent and professional and correct. Okay, so whether it's information on your website or in any marketing material that you've got, or any introductory letters that explains your service, make sure that you're explaining it correctly. Intake forms, agreements to mediate, mediation summary reports, or MOUs or progress notes, whatever work product you deliver. Make sure again that you're consistently identifying these things correctly. Okay, so, and number one, use plain language. Don't use legal language, although you'll see in the precedent in the paper that I'll direct you to, I have used too much legal language. So it's a work in progress for all of us. But use plain language as much as you can in your own words, explaining, what confidentiality means, right? And explain confidentiality and explain without prejudice separately in your agreement to mediate. These are separate concepts, break them out and explain them fully and explain them, in language, again, that clients will understand, right? Confidentiality means it stays here. You can't share it with other people. And sometimes people will say, well, can I talk to my lawyer? Yes, of course, your lawyer's your agent. So of course you can share that information with your agent. So your agent may be your accountant, your agent may be your therapist, right? Your agent may be your lawyer. Yes, you can share information with those people whose advice you need in order to make informed decisions in the mediation, but you can't share it with people outside, that parameter, that kind of relationship. Why? Because it undermines the whole integrity of the mediation process if parties, think of the case, where the unhappy party took out the ad in the newspaper. And then without prejudice, make sure they understand what that is, right? That means you can make offers and proposals here and not be worried that they're going to be that they're going to be used against you at a later time. Okay. So that's without prejudice, and that's confidentiality. And make sure that you use those same explanations in your intake form, in your mediation summary report preamble, in your agreement to mediate, right? That's where you want to be sure you're consistent. And of course, exceptions. Make sure that whatever exceptions there are to those concepts are also consistently and fully explained. Okay, so that is tip number 1. Tip number 2, based on what we've learned, right, from Bouvier and then Butler, we are stuck with the common law exception to settlement privilege. Okay, so contract out of that exception to settlement privilege if you don't want, if you want to make sure that parties can't, under any circumstances, look to your process as evidence for whether a settlement took place or not, or what its terms were, right? So the question that you want to ask yourself is it better that that parties, in certain circumstances can look at what happened in the mediation to prove the existence or terms of a settlement, or is it better that they can't ever? You have to pick a side, and whatever side you pick, be clear about it and make sure you explain it clearly and that your document is really clear about which way you're going to go on this one. And if you read, and I would recommend that you read the majority decision in Bouvier as well, because there's a very compelling argument for the waiver of settlement privilege, right? And it's this: you don't want to be party to a process of bad faith. You don't want to be a party to a process where one party basically strings everybody along, enters into tentative agreements, spends the other party's money, wears them down, and leaves them in a position where they think they have a settlement, right? And then, the next day, the party turns around and says, oh, you know what? I changed my mind, right? That's one of the big risks of mediation, isn't it? Right? Because our clients enter into agreements to agree. We don't have our clients sign binding agreements in our processes. Our agreements to mediate say that they're supposed to go and get legal advice and formalize it some other way. And in most cases, that's a safe and empowering process, right? And in fact, it's quite empowering to be able to say to people, you know what? You can walk away from this mediation and change your mind tomorrow, and that's okay. And that's how confident I am that you're going to come up with an agreement here that's better for you than any other alternative. That's why you can walk away from this process and change your mind tomorrow, because I'm pretty sure you won't, right? So, but in some cases, parties will take advantage of that. And that's the argument in favor of the exceptions to settlement privilege, right? So just bear in mind that there isn't necessarily a right or a wrong here, but pick a side and then make sure that you're explaining it and that you're consistent. And I guess the only piece I would add is I believe this: if you are screening carefully, right? And not just at the beginning, but throughout, and you're explaining your process carefully. Hopefully you will have relatively few cases where that kind of bad faith bargaining is happening in your process. Hopefully you're going to screen those people out and say, you know what, you are better off in court, because you're going to abuse the mediation process, right? Because to me, it's a lose-lose, right? If parties have to go through your mediation and then, you know, there's uncertainty about whether there was a settlement afterwards, or one resiles and then the other one has to go to court and argue waiver of settlement privilege, right? I mean, who needs this, right? These people should have been in court all along, right? And this is the argument in favor of very careful and thoughtful screening. We do not take every case that comes through the door. Why? We don't want to do harm, right? We want to make sure that if this is that kind of case, those people would have been so much better off, right, just being in court in the first place. So think it through and make a decision. As you will see in the templates that I've given you in the appendices to the paper, I have decided in all of our agreements, mediation and PC2, by the way, to waive or accept. It's an exception to the exception, right? To say under no circumstances can anybody ever come and dig through this process in a court, right? So I have completely waived the exception to settlement privilege. And just by the way, I know this isn't a parenting coordination seminar, and I want to make sure there's time for questions and discussion. But if you are going to include the exception to the waiver or the exception to settlement privilege in your parenting coordination or mediation arbitration practice, make sure you have a protocol for converting consent awards or consent settlements in the mediation phase into awards, into binding awards, right? Otherwise, you run into problems, right? So it does create some potential procedural challenges in the parenting coordination process, and you want to think that through. Okay, and I'm happy to talk about that a little bit more. Okay, best practice tip number 3, I'm sure you all know this already. Sign the agreement to mediate before you do anything at all in your mediation, all right? Do not start a mediation process without that. Why? Because you don't exist otherwise, right? Even in the court connected context, right? Because we don't have court ordered mediation here. You're nothing. There's no protection to any email or any communication you may have with the parties associated with mediation if there isn't an agreement, right? So that we only exist in a private contractual world in family mediation in Ontario right now. Wigmore, as you know, might provide some common law protection to your communications with parties, but as you saw in in the case law that we've been reviewing today, not necessarily, right? If there's no signed agreement to mediate, Justice Lemon, if your case ends up in front of Justice Lemon, he may well order your file disclosed. So don't take that chance. And think through what your process is going to be to cover off confidentiality for intake meetings. So there's 2 different ways of doing that. One way, and this is the way that we've adopted, especially during the online era, is to have the parties sign the agreement to mediate before they do their intake meetings, right? So we have parties submit their intake form and sign their agreement to mediate at the same time. Why? I want to make sure everybody understands that this is confidential information, right? I go back to Kit and Benson and say there are lawyers out there are parties out there who may try and undermine, who may try and get that information. And intake information, screening information is so important, must be kept confidential. So I prefer to have parties sign the agreement to mediate at the same time as they submit any confidential information to me. Number 1, they know that there are exceptions to confidentiality. And number 2, I've explained to them that just because you sign the agreement to mediate doesn't mean you're going ahead. It's just to cover off the confidentiality of the intake process. And this is still a voluntary choice to proceed with mediation. So even though you've signed the agreement to mediate, that can't prejudice you if you decide not to proceed, okay? The other way to do it is to have a 2-step process, and I know some very good mediators who do it this way. They have the parties sign a mini agreement for confidentiality of the intake meetings. then once the intakes take place, if they decide to proceed with mediation, they have the parties sign the agreement to mediate. This is what we do at Riverdale in our parenting coordination practice. We have 2 separate documents. And with online intake forms, you can accomplish a lot of this by check boxes and save yourself some trouble. But either way, make sure you do not do an intake meeting with a client or receive an intake form without a contract in place protecting the confidentiality of that information. And think Arbuckle if you have, if you're not sure whether that's a good idea or not, and that will cause you to decide that that's a good idea. My own bias best practice tip number 4, don't do open mediation, real open mediation. I know some very good mediators do it. To me, it undermines the safety of a confidential, safe place to have difficult conversations. It changes your role. I don't even think that, from my view, that really, you're mediating with at least one hand tied behind your back in an open mediation, and the parties are participating with one hand tied behind their back. And I think if parties need open mediation, my view is they probably should just be in court. But that's my own biased opinion. So for more information, and then I'm going to go to the chat, right? These citations for all of these cases I've referenced, the Arbuckle decision, the full unreported decision, a sample language for intake forms, for confidentiality, for without prejudice preambles for your agreements to mediate and for your mediation summary reports, as well as a sample exception to the settlement privilege exception language is all in the paper on our website. So this is a link to it here, but you can go to the Riverdale Mediation website and you can find it. If you see the tabs across the top here and you go to the tab that says News and More, you drop down on the News and More tab and you will see articles. And this is in the article section of the website. And of course, feel free to subscribe to our newsletter, and you will get our newsletters and information about what we're writing as we write it, or follow us on Twitter and LinkedIn, because we do write a fair bit about these kinds of cases as they come up. Okay, so I'm going to.
I'll help you with the chat. That's good. So good. So good. My head hurts part 8, 9, 10, 11, 12. This is really, it's good stuff. I think there's probably going to be some good questions for you in the chat. We're just talking about that idea of the 2-step process. Like, I learned that last week we taught intergenerational mediation at OAFM, and one of the participants talked about that 2-step process. And I was like, that is so smart, because you're sometimes you're just chatting with someone and you've written down notes, and we've had members who have been challenged to give over those notes and had no protection because there's no contract. So it's really interesting that that's coming up. And I think that we should really think about that in our roles as, taking that extra step. Lots of people are agreeing with that. And I know we're a big group, but you could unmute and ask a question if you want, or just use the chat and I can help read it out.
Well, let me just go through some of these pieces in the chat right now. I'm just, actually, do you know what? I'm seeing, I think I can't see them, Marianne. I can only see some comments.
Yeah, there's not many questions in. I think you've done such a great job, and I love the way that you made it a little fun, right? Like it's nice and it feels good to have you say your head hurts because my head hurts, and I think that we're not alone. Let's see if there's other questions. I've got a new message, lots of message popping in. Okay. What's your opinion about the industry moving towards an agreement to mediate industry standard to address these issues? That's actually come up a few times at OAFM.
Yeah. You know what? So personally, I get frustrated when I'm being asked to use some kind of document that somebody else has prepared. Because it means you better make sure that you're on top of things, right? Like I stay really on top of these things. I change my agreement to mediate several times a year. I change my intake forms probably monthly. I mean, I'm updating stuff all the time. So personally, from a best practices standard, I'd be very nervous about agreeing to follow anybody's template. On the other hand, if there is a template in place and it's accepted as the industry standard, then to some extent that takes the responsibility. Then you're meeting your due diligence, right? You're meeting the expectation of you as a professional because you're using the industry standard. So from a negligence point of view, I suppose it could be protective, but you'd have to make sure it's really good and make sure that you've got people updating it all the time who are staying on top of the law. I guess that's what I would say about it. But it may be a really good thing to do for a lot of people who aren't able to stay as current with the law, right? As some of us may be.
I think at OAFM, we grappled with that idea as a standards committee and as a board. And the common thought was very much in line with what you're saying, Hillary, that these are all professionals who have different needs for a retainer contract. So OAFM to prescribe something didn't feel right. What we did was tried to set out, and you'll see them soon, hopefully next year, the new standards of practice, setting out some really key points. And also that idea of continued professional development in the area, like that what you just said about changing your retainer contract, and it was quite inspirational. I don't know if anyone could meet that on this Zoom call. I certainly can't. So I think that's, you're probably in the lead there with making amendments. Another question.
The other thing I'll just say, Marianne, is I really like what you just said. When I first created my very first agreement to mediate 20 some years ago, I went to the only source I could find, which was the OAFM standards of practice. And I used those, and I just said, okay, I'm going to incorporate all this into my own agreement to mediate in my own words. And I think that combined with programs like this should really be the best way of doing it.
Right. And then the ministry prescribed contract, as you've said, are there. So if you're doing the ministry court connected program, then you are using their words. So that's another one. And then there's a question, this also came up, where during the pandemic, access to Wi-Fi and the ability for people to actually physically sign something or sign electronically has been challenged. And so we're looking at the acceptance of acknowledgement of adhering to the agreement to mediate by email, by phone, and by documenting. So this is something that OAFM has addressed in its more recent version of the standards, to say that yes, that meets the standard. Have you any thoughts on that?
So with everything, right, there's pros and cons. You have to be really careful about that then, because it's hard enough administratively to make sure that you're managing your files, right? So it's one more piece of paper that you have to print out or copy over to your drive or wherever you save everything, right? So I'm not in favor of any more pieces of paper or any more documents that we need to cobble together in order to have a binding agreement. That also could lead to a lot of problems. To me, that would be a last resort, let's put it that way. And it also means that you have to then get your confirmation of identity at that time, right? So the person who's sending the email, you really have to get on the phone with them or get on a Zoom call with them and say, did you send that email, right?
Yeah.
So lots of problems with that. But you know what?
Yeah.
Become so creative in this time. I would just say, think through every step of every adaptation, because there are new problems that are being created as quickly as we're creating solutions to the old ones.
Yeah. I think it's a proceed with caution. I think Michelle is asking you to expand on your comments in relation to PC agreements, to make sure that it states consent to agreement can be converted to an award.
Yeah, so that's, if you look at take a look at the PC agreement that I've edited since Bouvier on the Riverdale Mediation website if you want, because I think it addresses that. So typically PC agreements that I had seen previously provided that in the mediation phase of the parenting coordination process, if parties, just like mediation, right? If parties reach a mediated outcome, it's not binding. They have to go get legal advice on it and make it binding with their lawyers. Well, that completely kind of undermines the whole point of parenting coordination, don't you think? The whole point of PC is for them to not have to go back to the lawyers and get legal advice on it. And so what I've done is and as well, so what I've done is I've clarified that we still, in essence, have the same arrangement, right? We reach agreements in the mediation stage, but they may not be initially binding. So what I've provided is that there's like a 30-day period in which, if they reach an agreement in the mediation phase of parenting coordination, I will draft it up. And within 30 days, they agree that it will be converted into a consent binding award. And they've got 30 days to go get legal advice and confirm if there's anything wrong with it. And if there isn't, it then becomes a binding award, and I can make it binding. And that's really important, because you need that if you're going to waive the exception to settlement privilege, right? Because otherwise what can happen is a PC, you reach a settlement on a matter, you do your PC summary report, it never gets converted into a binding award. You know, they go along with it, and then a year later, one of them says, oh, actually, I don't agree to that. Now you have to arbitrate everything because you don't have anything. Okay. Whereas if the settlement privilege exception prevailed, you could still arbitrate, but you'd be able to look at your own PC summary report as evidence of an agreement. Okay. So it's just, it highlighted the benefit, whether you waive settlement privilege or not, settlement privilege exception or not in your parenting coordination process, you still should change your agreement if it says anything that's agreed to in the mediation phase is not binding. You should still change that, because that is quite ineffective and quite unfair to parties. This is supposed to be a proportionate process. Hopefully I explained that. Thank you. Okay, what else?
Would you believe it's almost 2 o'clock? It's 1:59. There's another question. Just sent a couple of direct messages about that whole idea of the intake retainer contract, or what to do with personal information. I think that's I really think this 2-stage thing. I'm going to look at that a little bit more. And just see if I can dig up some wording somewhere and share it on a Mediation Matters with y'all. And we can go over that to see if we can have a best practice, or just like a practice tip that can help us through that. I want to say thank you so much to Hillary for, first of all, for writing the article, and then for agreeing to do a PowerPoint and come on here on Speaker's Corner. You can see you had over 80 participants. So this was a topic that was, people were emailing saying, oh my God, I'm not going to be able to come on. Can I watch a recording? This is going to be recorded and on the resource page of OAFM, as well as tons of other past presentations. This one, I think, will probably get lots of views, and as we make sure that we're doing the right thing to protect ourselves and also our clients and their families. So thank you very, very much for spending this hour with us. December 12th is the next one on marketing, getting ready for 2023. So hope to see you all there. Take care.
Thanks, everybody.
Thank you.
Marianne, I